All right, I am attorney Ashley Lillesand Leonard, and I get to meet with all of you today. I see some familiar faces, which is always nice. Two things about me that I think would be helpful to know before we jump into the really fun estate planning topic for the day. The first thing is that when I am talking to you today, I am talking with you. I am not talking at you. And what I mean by that is when I graduated from undergrad, I was a social worker before I went to law school. And I worked in corporate guardianship, which is where individuals who unfortunately haven't done any estate planning or have family members or friends who are taking advantage of them, they get appointed a guardian through the court. And I worked for a nonprofit organization that provided that guardianship service to these individuals. And I saw people who had to spend through their life savings because they hadn't done any planning. And I did Medicaid applications for them. And I sold all of their real estate and all of their belongings because at that point in time, it was too late for them to do estate planning. So when I say that I'm speaking with you, what I mean is that I have served in the trenches in terms of helping people who didn't get estate planning done when they had the capacity and when they had the ability. So I'm not speaking from an ivory tower of not knowing what it's like to be in the position of needing Medicaid or funding to pay for care if you haven't done any estate planning. The other thing I point out is, and my website says this, but I'm the least lawyer-like lawyer you will ever meet, unless we're in court, and then I'm very lawyer-like. What I mean by that is I want you to feel like you can ask questions at any time. I'm very approachable. I try to talk like a regular person. I try to wear my social worker hat more than I wear my lawyer hat so that it's a situation where you feel like you are comfortable doing this. I don't think there's any value in meeting with an attorney who talks down to you, whose goal is to make you feel like you don't know what you're doing, and you walk out with a really expensive binder and you don't have any clue what it does for you. I am a huge proponent of making sure that people understand what they have, what it does for them, and providing sort of ongoing guidance to people as the years go by and things might change with your plan. So ask questions. If you have really specific, nuanced questions about your own situation, I will be around afterwards and we can talk. But feel free to raise your hand and ask a question during the talk if there's something you think might be helpful. I do love the, well, my neighbor told me questions. So if you have any of those that I'm dispelling myths, feel free to raise your hand and ask. Okay? All right. And we're going to see if we can make this work. Okay, so the reason that we do estate planning, lots of reasons. The number one reason that I get from people when they come in to meet with me is they want to avoid probate. So what is probate? Probate is a court process wherein an individual who has passed away, who has a will, or who doesn't have a will, goes through the process of having their estate administered. And the court is involved in this entire process. So from the start of either presenting a will if you have one or having what's called an intestate estate, meaning you've done no planning, the court appoints a personal representative. Frequently people refer to that as an executor, but in Wisconsin it's called a personal representative. And that person is going to handle the estate. So it is a 12 to 18 month court process. And most people have heard horror stories or have done probate with their parents or family members and realize they don't want their kids and their loved ones to go through probate. So that's a frequent reason for why we look at doing estate planning, because there are a number of ways to avoid probate if you do estate planning successfully before your death. We do also want to make sure that our wishes are carried out. So I do hear people say sometimes that if you haven't done a will, that your whole estate is going to the state. That's actually not true. Your estate is going to go to your next of kin, but your next of kin might not be your intended heir, especially if you have a blended family, or if you don't like your siblings, or you're estranged from your kids. Your next of kin is who the law says your estate goes to if you don't have a plan in place. So if you want to say and where your estate goes, you have to put something in place, not just assume that it's going to get to where you want it to go. Yes?
What is that order?
That's a good question. So in Wisconsin, it is spouse. And if you have children not from the marriage that you are currently in, then if you were to die without a will, 50% would go to your current spouse and 50% would go to your adult children not of that marriage. Does that make sense? If all the children are of the marriage, then it's fully 100% to the spouse. Then it's your adult children, if your spouse has predeceased you. Then it's your grandchildren. Then it's your parents. Then it's your siblings. Then it's your nieces and nephews. And then it goes to like cousins from there. So I also will hear sometimes people tell me, well, I don't have any heirs. Everybody has heirs. They might be far-flung and you might not know who they are, but there are heirship firms out there whose job it is to find people's heirs in cases where you die without a will or an estate plan delineating who those heirs are. So I tell people all the time, your great Aunt Nellie might die and leave you, $100,000. People say, I don't have a great Aunt Nellie. Everybody has a great Aunt Nellie. They might not give you $100,000, but there's really no such thing as not having any heirs. You just might not know who they are. So if you haven't put something in place, they might be benefiting from you not having done a plan. Okay. Make sense? We do also want to avoid estate taxes, and this is kind of a gray area right now. Currently, the estate tax exemption for a married couple is just under $28 million. So that may or may not impact people in this room, but that number could change, and it does change from time to time. So it tends to be linked to who's in office, who's the president, whether it goes up or down. I don't particularly think it's going to go down extremely low again, but it is something that we factor in when we do planning. As an aside, we do not have inheritance tax in Wisconsin. So meaning, if you sell your house, your kids sell your house upon your death, or your people you've appointed sell your house, and those funds get distributed to kids or whoever your beneficiaries are, they don't pay taxes on that. That would be inheritance tax. Some states do have inheritance tax. Fortunately, we do not, which is the other reason why we don't have to inventory and value every single furnishing and art and everything you have in your house, because none of that is subject to what we call an inheritance tax. That is different from an estate tax, which is different from a fiduciary tax. But from a broad spectrum tax idea, most of the planning that I do with people, we are not having to take tax considerations into what we're doing. Okay, does that make sense? And I always like to say, nothing brings out the best, in huge air quotes, in people like death and money. And it doesn't take very much money. And sometimes it isn't money. Sometimes it's fighting over the garden gnome collection that nobody wanted during your lifetime, but everybody wants now. And I say that in jest, but I also say it in full seriousness. I have seen so many cases where your kids end up never speaking to each other again because they're fighting about something that's relatively trivial in the grand scheme of things. And so I always tell people, it's your job to hope for the best for your kids and your beneficiaries, and it's my job to plan for the worst, because I assume the worst is going to happen. And if it doesn't, great, wonderful. I love being proven wrong. But I also like you having a plan in place that is the if this, then that, if the bickering starts and people start fighting, and trying to avoid the lawsuits and things that come out of people fighting about the garden gnomes. Okay? Oops. There are several reasons as well why we need a estate plan. So if you own real estate, especially if you own real estate in more than one property. So if you have primary residence here and then you have a condo in Florida or Arizona and you don't have a plan, you not only get to do probate in Wisconsin, you get to do another probate in the other state. It's called an ancillary probate. And depending on what state that is, let's say it's Florida, I've seen those take 5 years to settle. So the only thing worse than being stuck in a probate in Wisconsin is being stuck in a probate in another state. So definitely consider that if you own multiple pieces of property and if one of them is in a different state. If you own businesses, we certainly need to have a plan in place. If you are in a second marriage or after a divorce, a lot of times people don't update their plans after they get divorced. Some of those things are presumptions that maybe the spouse doesn't get the money, but I wouldn't leave it up to a presumption. I would go ahead and make sure we get our plans changed, beneficiaries changed on things. If you get divorced, or if you have a second marriage situation, we got to take into account what does that look like. If you have any disabled family members, we need to take them into account differently. We need to do a special needs trust for them, which makes a huge difference. We can't give a pile of money to someone who's disabled and hope that it's not going to upset their funding. Okay, the funding that's really important that they receive for a group home they might live in or services that they receive. And there's ways for them to receive funds, but you have to set it up correctly. When you have minor children, so probably this isn't you all, but your kids might have minor children. It's really important that they have at least a will. A will delineates who takes over guardianship for minor children if something happens to both of the parents. And again, unfortunately, I see people come out of the woodwork to fight over getting those minor children because there's money associated with them. There's a Social Security death benefit that accompanies minor children. There's, the estate of the parents is going to somebody to manage. And the last thing you want is your kids or grandkids being raised by somebody just because they saw dollar signs associated with them. So tell your kids they need a will. If you want to leave anything to charity, if you have substantial assets in 401ks or IRAs, this is that taxable estate that I referenced before, which again, doesn't usually come into play recently with the high levels, but and even if none of these things apply to you, none of this matters to me, I don't have any of these things, you still need a basic plan. And a basic plan is going to consist of a power of attorney for health, a power of attorney for finances, and at a minimum, a will. And those can be simple. They don't have to be elaborate documents, but they're important. Okay. So here we are with these components that I just referenced. A power of attorney for health is also called a living will. It's also called an advance directive. It's also called 5 wishes. It's called lots of things. But what you need is a document that names a person to be a decision maker if you end up incapacitated. So this could be you have dementia. It could be you have a stroke. It could be you get in a car accident. Incapacity might be temporary. It might be permanent. It's a kind of a broad umbrella of what incapacity means. But if you don't have somebody in place, you're going to end up in court in a guardianship situation like I referenced before. There is no presumption that spouses or kids can make legal health decisions for you if you haven't done this document. Everybody thinks, oh, my wife can just decide for me. No, actually she can't. And especially if you have a wife and kids and they're not of the same marriage, there's going to be a fight. So you want to make sure you have a healthcare power of attorney named. You can only name one person to act at a time under a healthcare document. That's by design. That's so you don't name the wife and the child who's not in the marriage and they can't agree, and then you end up on life support while they fight it out in court. So you can name subsequent people who would act if the first person can't, but you cannot name multiple people to act at the same time as your healthcare power of attorney. The durable power of attorney for finances is the piece that allows your named agent, typically your spouse, or again, children, whoever that might be, to stand in your shoes financially if you're incapacitated. This is everything from getting your mail, to paying your bills, handling your taxes, inquiring about insurance claims on your behalf. It's everything. And so again, I hear spouses say, well, I'm already on the joint account. But you're not on every account because retirement accounts are always individually held. There's no such thing as a joint retirement account that's an IRA or a 401k. So when you're the spouse and you pick up the phone and say, my spouse is incapacitated, I need to get information, too bad if you don't have a power of attorney that gives you the authority. Yeah?
Does that allow them to make financial investments?
It can. It can. So the document that I prepare, there's a number of enumerated powers that we go through, and we make a decision which powers we want to give to the person that you've named. You don't have to give all the powers, but we want to be sure that we've given enough of the powers that they can meaningfully do what needs to be done on your behalf. Okay. Yeah?
You don't have to be or they don't have to be incapacitated for the finance.
Technically, correct. So technically, the healthcare power of attorney is what we call a springing document, meaning that you draft it when you're lucid, you're fine, and it comes into play and is activated when 2 physicians declare you to be incapacitated. Okay, and again, that can be any number of things that cause that incapacity. The financial document is effective immediately upon signing it. It does not require a rendering of incapacity. Now, if you have both these documents done and your healthcare power of attorney gets activated, it stands to reason that probably you need your financial power of attorney to step in as well. There are pluses and minuses to the fact that the documents are drafted that way. I always advise my clients not to give out their financial power of attorney to their named agents until they need that person to act. Because literally that person can take that document today and go to the bank and act on your behalf. Again, We're all hoping everybody you've named is trustworthy and going to do the right thing, but we're also going to put in place safeguards to ensure that maybe they're not given power they don't need until they need to actually act on your behalf. So, does that make sense? Does that answer the question? A will, again, a will is a bit of a archaic way to handle most people's estates these days, only because most people own real estate, and real estate, if you have that and you have a will, you have to go through probate. A will is just a suggestion to the court. In and of itself, I can't take a will and go into the bank and say, here, this will nominates me to be the personal representative, so therefore I get to act. No. A will has to be an original will, validly executed, has to be given to the court. The court has to find that A, B, and C were done and it was done right. The court then appoints the personal representative, and then that person receives domiciliary letters, and that's what you would take to the bank. So a will in and of itself must go through probate if that's the method that you're using to handle your estate. Revocable trusts are great. They avoid probate. So a revocable trust is a self-governing instrument per se. It doesn't need the court's involvement. It doesn't need the court to appoint anybody or have any oversight. It nominates what we call successor trustees. Those are the people who function in that executor capacity once you're gone. People under a revocable living trust have all the same authority to act as the person named under a will, but they don't need any court involvement. So, a lot of benefits to that, and it's a great way to, at a minimum, when you set up an estate plan, avoid that probate process. Yeah?
If you have a POD and or a TOD, do you still need a revocable living trust?
Well, that depends. So, all the answers are that depends today, just so you know. PODs, so payable on death designation on bank accounts and investment accounts and life insurance and everything, is the most efficient and free estate planning you will ever do. Do it on every single asset you own. Every bank account, every life insurance policy, every CD, every IRA, everything. Have beneficiaries named. It is simply a form that you fill out. If you work with Drake, they can help you do the forms. If you need to go into your bank, you tell them you need a POD, and you're going to name a primary beneficiary and then contingent beneficiaries. And so those assets that have beneficiaries pass outside of probate and outside of a trust. Very efficient. Upon death, your people fill out a claim form, they submit a death certificate within weeks. I mean, they're getting checks for their share. So it's very efficient. It's a great way to handle the vast majority of your assets. The TOD that you reference is traditionally referred to when we're talking about real estate. I am not a fan of TODs, and this is why. When you transfer a bank account, POD, to let's say your 3 kids, they each fill out their own claim form, they each get their own share, they each can go on their merry way and do whatever they want with it. If one of your kids is delinquent and doesn't fill out his share, doesn't fill out his form, that doesn't prevent your other 2 from getting their share, okay? It's just divide it up. When you TOD your real estate to your 3 kids, they now co-own your property equally. No one of those 3 is actually in charge. So this means they have to agree on everything. Are you going to sell it? Are they going to keep it? Is somebody going to collect the rent and not tell anybody they've collected the rent? What color are they going to paint it? What realtor are they going to use? All the things that, again, you're hoping your kids are going to agree on just so that you could not do a trust and do a TOD because it's quicker and cheaper and easier. There's a high likelihood that sets your kids up for litigation. And I've done a number of these cases where I represent a couple of the siblings, and one has gone rogue, and he's collecting rent, and the other 2 didn't even know people were living in the house, and just all the horror stories that you can imagine when you give a piece of property to multiple people with the intention that it's going to be sold and disposed of. Not necessarily a family cabin where you're keeping it, forever. That's a different scenario, but I still don't necessarily believe in TODs. We'll get to that. But TODs, a lot of people say, oh, just do a TOD for your house. It's super cheap. Yep, until your estate ends up spending $30,000 fighting about it in court. So if you have 1 beneficiary, a TOD can be fine. If you have more than one, I do not recommend it. It doesn't, no one's in control. No one has any authority. So therefore, everyone has authority. And it just can set up a really bad situation. Okay?
Well, that's the cons of that. The pros of a trust would be,
That someone's in charge. So you name a successor trustee under a trust, that person is in charge. That person decides what color they're painting it and who they're listing it with. Now, hopefully if that's one of your kids, they're working with their siblings, hopefully, but at least somebody's in charge, not 3 or 4 or 5 instead. So yes, that's the difference. The irrevocable trust is also avoids probate, but its real purpose and goal is to protect assets from a nursing home, which we're going to talk about more in a minute.
So in your will, can you put in your will that you want the house sold?
You don't,
Both of you dying, and then the TOD would be fine?
no, because those two things negate each other. So under a will, you don't need to say that it's going to be sold upon your death. It's just that's what's understood.
Right, but that would that go and say they can't rent it out?
No, because once you TOD it upon your death, they immediately take over ownership of it, and the will does not govern it at all. So again, you're back to the scenario of no one's in charge. So you would do one or the other of those. Together, they really negate each other, unfortunately. Yes? Well, you sound like people who've come and worked with me before. A pour-over will is what you have when you have a trust. So under any kind of a trust, you have a backup document called a pour-over will. Its job is to capture any asset that you didn't put in your trust during your lifetime. Maybe we forgot, maybe there's a reason we didn't do it, but it then pours, that's why it's called POUR, pour-over will, it pours that asset into your trust for distribution upon your death. So you still need a will when you have a trust, but it is not a standalone will. You would never have a standalone will and a standalone trust because, again, those things would conflict.
Would you have to word that different then?
It is worded different. Mm-hmm. Okay. Yep, in a pour-over will where it says I give, devise, and bequeath, normally it would say all my assets to so-and-so. It says I give, devise, and bequeath anything not in my trust to be put in my trust. Yep, exactly. Yeah?
on a revocable living trust, does that have to be filed ahead of time with anybody? Or?
Trusts don't get filed anywhere, which is the other thing that's nice about them. When you do a probate, your estate is out there for anybody to look at. The inventory value, the assets that you have, most people don't really want that to be part of public record. Trusts, you don't file anywhere.
Well, when I've seen property records for like our neighborhood, I see houses that are listed as in trust.
Yeah, and that's the name of the property. The owners have changed it from their individual names into the name of the trust, but that's the most anybody's going to see. They don't see any of the terms of your trust. The trust doesn't get filed anywhere itself. Correct. Yep. Yeah.
If we have a trust and it was done like 20 years ago and you don't really know if it's up to snuff, whatever, do you look at something like that?
I do. Yes, I do. So I'm happy to review documents for people. Now, the only caveat is if you did it on LegalZoom, I'm not going to rubber stamp it. I just can't, in good conscience, get behind saying that I know for sure this was done right. If an attorney did it for you, even if it's really old, I'm happy to look at it. I'm happy to tell you if it works for you. I'm happy to discuss with you whether or not there's anything actually in it. Because a lot of times people have a trust, and I say, what's in it? And they look at me like, what does that mean? What that means is when you create a trust, you create an empty box. A lot of people have this assumption or presumption that by virtue of signing a trust, magically all your assets are in the box. Nothing is in the box. Understand that when you leave here today. Nothing is in the trust box until you put stuff in the box. And the way that you put stuff in the box depends on the asset. So if it's real estate, we have to do a deed, just a simple deed to change the ownership from you as husband and wife or you as an individual into the name of your trust. If it's a bank account, a life insurance policy, we have to do a change of ownership form through whoever hosts that asset for you. So there is no such thing as trust just magically having everything be put in them. And a lot of times attorneys do trusts, but they don't fund it. They don't help you fund it. They don't tell you what to do. They give you a binder and say, here you go, good luck. Well, why would you know what to do? Why in any universe would you know how to fund a trust? And when you know, until a day ago, you didn't even really know what that word was. So we help you fund it, but if you have an existing trust, we're going to look and see if it has been funded, and if it hasn't, you can always fund it. You're never too late to fund it. So that's one of the most important things about a trust, is to be sure that not only did you create it, but you put stuff in it. Yeah?
If you have a trust, revocable or irrevocable, and you set it up while you're a Wisconsin resident, and then you change residencies and move to another state,
Great question.
is it still good?
It is. Trusts travel with you. The situs of a trust is where the trust is hosted. That can be where it was created, it can be where you moved to, or it can eventually be where your trustee lives. So trusts cross state lines. You don't need to get a new trust if you move to a different state. The only, I guess, little asterisk on that is, I will say, if you come here from a state where that's not a community property state, so you come and your husband and wife and you have individual trusts, a lot of times I'll advise people to create a joint trust just because it's easier here, but you don't have to. It's not wrong. And conversely, if you go to a state that only does individual trusts, you don't have to switch from a joint to an individual. But yes, trusts travel with you. That's very convenient. Wills do, yep, they do. Now, again, you're subject to the probate laws in the state that you now live in. May or may not be more user-friendly, but yes, wills do travel as well.
So the question I have is, I have an irrevocable trust.
A revocable?
Irrevocable.
Irrevocable, okay.
I have the house in there.
Okay.
Now I go to insure the house. Can I personally pay the insurance for the house? I was told I can't because I don't own the house. You can't insure a house you don't own.
You know, I've not run into too many insurance companies that aren't willing to take the money from nowhere, no matter where it comes from, quite honestly. From a strict standpoint, when you own a property in an irrevocable trust, you don't own it anymore. Your trust owns it. So what he's saying is, are you then allowed to pay out of your own pocket for the insurance? Again, I would like to see an insurance company tell me I'm not willing to take your money to insure something, because you have the ability as trustee of your irrevocable trust to get the policy. I don't think it makes any difference where the money comes from to pay for it. I don't know. I would like to know what they told you.
I had a tax guy that argued that and told me that I couldn't pay that. I had to pay the trust and then have the trust pay it. The taxes were the same thing. Which company?
Yeah, that's kind of not sound advice. I'm not saying you weren't told that at all. And for everything I tell you, you'll find 10 other people who will tell you something different. So you take from this what makes sense to you and what you believe in. But it shouldn't make any sense where the money comes from. I mean, if you bought in a pile of cash to pay for your policy, would they tell you they're not going to take it? Right? Where do they know where the cash came from? So to that extent, I just can't, I think that's not very good advice, because I think the money, wherever it comes from, shouldn't matter. Well, that's what I mean. It doesn't, it shouldn't matter. I'm sure you were told that. I just don't think that's based on really sound advice. Now, irrevocable trusts do allow you to use funds in the trust to pay for a trust expense. Meaning, if you had an account in the trust and you had some cash in that trust and you have real estate, you could use the trust funds. You're not allowed to spend the principal on willy-nilly things, but you could use the principal to pay for the homeowner's insurance of the property that's in the trust. So that's not wrong either. It's just a lot of people don't have cash in their irrevocable trust. They only have real estate, life insurance, things like that that aren't cash available assets. Okay. Oh, I got to talk faster. I kind of went through some of this, but in terms of a probate, you're going to court. One way or another, you're going to court. An application for informal, a petition for formal. There's going to be at least one hearing. Once the person's appointed, they have to publish for creditors, they have to do an inventory, they have to do a final accounting. There's a lot of things that the court does for good reason, because if they're in charge, they want to make sure that everybody's doing everything right. And there are occasions where we've got a really hostile situation that I have told people, I think you should go through probate because you want oversight on your situation. Yeah.
What starts the probate process?
Well, death starts it first.
But just because someone dies does not mean there's going to be probate.
Absolutely not. No. So, I mean, I get appointed from the court on cases where someone died 15 years ago and nobody's done anything about it. So, death in and of itself is, I'm kidding, is not the first thing that starts it. Somebody has to make an application to the court. If you have a will, you must present the original will. If you don't have a will, then you're presenting an application for intestate probate. Again, that's where we go through that hierarchy of who are your next of kin. If you only have a copy of a will, your attorney or someone is going to have to find out if anybody who signed as a witness or as the notary can testify to what's called a proof of will to say that they validly recognize that will to be what they signed, the copy of it. Sometimes that flies, sometimes that doesn't. So if you have a will and that's your main instrument and you don't know where the original is, you need to get it redone or re-signed or start over, because that piece of paper, that copy, is not going to get you very far. There's no guarantees that a copy gets admitted. And then if you don't have a copy or you don't have a valid will, then you're back to an intestate estate. So lots of steps, lots of things you have to do to go through probate. You know who likes probate? Probate attorneys like probate. They like it a lot. They make a ton of money. I mean, the other interesting thing is your estate is paying for this, but I mean, it's easily $10,000 to $15,000 for even what everybody tells me their estate is simple. It's a really simple estate. It doesn't matter. It's still a process, and most attorneys make a lot of money off of this. You can do a trust for a half or a third of that cost and save yourself the probate. So then there's just lots of reasons to do a trust and very few reasons that it's not a better route to go. Okay. We talked about this a little bit. Spouse is not automatically the decision maker. Also, anyone over the age of 18 needs a power of attorney. So your kids who are grown or your grandchildren who are grown, the parents don't have the right to make decisions for them once they turn 18. So it can be as simple as just getting a healthcare document if your grandchildren are going off to college. It's really helpful and important. And there are state forms that you can do online. I don't like the healthcare on state form online, but that's a whole separate thing. Something is better than nothing. So if your grandkids or people who are over 18 need one, there's now a financial power of attorney online as well. There didn't used to be. I think it's through the Department of Health Services that both those documents are available. You just have to make sure you execute them right. Some of them need witnesses, some of them need notaries. If you don't do it right, you don't have a document. Okay? This is the problem with that LegalZoom that I referred to earlier. If you do everything right on LegalZoom, great, you have a plan. If you don't do everything right, you don't know you didn't do it right until you've either lost capacity and someone's trying to use your power of attorney, or you're deceased and someone's trying to present your will. And then it's too late, and now you can't fix it. So that's the problem with doing documents. If you're not sure that you've executed it appropriately, you don't know until it's too late, and you can't fix it then. Okay. Again, reasons for the revocable living trust. So when I mentioned having property in multiple states, that's that ancillary probate. If you have a trust, even if it's here, you title your Florida property in the trust here, that trust governs everywhere you own property. We don't have to have separate probates in different states. We don't have to have probates at all. So it's very, very useful if you own property in multiple states. And a trust can hold all kinds of what we call non-qualified assets. So qualified assets are pre-tax investments, your 401ks, your IRAs, your retirement accounts. Those are qualified accounts. Pretty much everything else is what we call non-qualified. Real estate, life insurance, bank accounts, stocks, all these things. Years ago, if you had a revocable trust, they wanted you to title every single thing you owned in it. Your cars, your rowboat, your garden gnomes, all the things. That is not really necessary, and it's not the stand that we traditionally take. Now, as long as you've got beneficiaries on accounts and your real estate is titled in the trust, we don't typically need to name the trust as the owner on every single thing you own.
Could you repeat that?
Yeah. So, like I said, so years ago, if you have parents who had a trust, they probably had every single thing they owned in that trust. Their regular cars, their bank accounts, checking accounts, everything was in the revocable trust. It's not wrong, but it's really unnecessary, because if you've got beneficiaries named on those accounts, that's where it's going to go upon the end, and there's no value to having your checking account or your regular car titled in a trust during your lifetime. If it's revocable, it doesn't change anything. So if you like going to the DMV and doing paperwork, you can do it, but most people it's not what we just don't do it that way anymore. It's not really necessary, as long as your real estate is in there. Okay? All right, the irrevocable trust is one of the most important estate planning pieces. Its purpose, in addition to avoiding probate, is to protect your assets. So you've worked really hard, you have assets, you're retired or getting ready to retire, And looking down the pike, everybody tells me they're not going into the nursing home, but unfortunately, some of us will. And so what we don't want is to spend all of our funds that we acquired and worked for our life at the nursing home. Average nursing home cost for a decent facility these days is about $10,000 to $12,000 a month. It's extremely expensive. It's very easy to blow through quite a bit of money if you end up in a nursing home and you haven't protected any of your assets. So only certain kinds of assets can go into an irrevocable trust. Traditionally, we fund it first with real estate that you have to own free and clear. It can't have a mortgage. That's the main difference between what we can put in a revocable versus an irrevocable. You can put other non-qualified assets, but what we put in that trust, you can't spend. So the goal is not to make you cash poor. The goal is to find a happy medium of what can I protect that I'm not going to spend through in my life. You still control it, you still manage it. You're still the trustees. So if you have a piece of property in there and you decide to sell it, you can buy something different under the name of the trust. You could sell it and keep the proceeds in an investment of your choosing in the name of the trust, and it stays protected. What you can't do in order to keep the protection is sell it and put the money back in your pocket. Because once it comes back into your individual name, now it's at risk, or now it's available again for the nursing home. Okay, so there are some caveats, there are some things you have to understand about an irrevocable trust, but the types of assets we put in it, the goal being not to make you cash poor, you're not even going to know, nothing about your life's going to be different if we do it right. We can also make what we call subsequent additions to this trust. So if down the road it appears you're sick, or your spouse is sick, or somebody might need a nursing home, and we were hoping not to be the case, but it is, we can sit down, with your Drake advisor, whoever it is, look at what you've got, look at what we can put into that trust in addition to protect, and it's two buckets. It's either in the you can spend it bucket and the nursing home can spend it as well, or it's protected. And we look at protecting everything that we can and spending what we can't protect. So it's a different way of looking at things, but it's important to note there is a 5-year look back. So everybody's probably heard these words. What the heck does that mean? 5-year look back means that Medicaid can look back up to 5 years to see if you divested any of your funds. The purpose of it is so that you can't be a bajillionaire one day and go into a nursing home the next day, give away all your assets, and claim indigency. So if you gave away your bajillion dollars more than 5 years before you needed the nursing home, then that's okay. But within that 5 years, they can look back and see if you divested anything. And now divestment is putting assets into a trust, giving away assets outright, also selling like your house to your kids for $1. That's a divestment. And this is where it gets a little tricky too, because the IRS, for example, says you can give away $19,000 a year to every person in your family under the gift tax exclusion. Medicaid says no, you can't. So the rules purposefully, I think it's purposeful, don't always jive. So you have to understand what you're doing when you're doing it so that you don't get yourself into a hole with Medicaid. Well, the IRS told me I could give it away. Well, that's not the Medicaid rule. So you have to understand both sets of rules when we're doing any gifting or divesting later in life. Okay?
So it has to be in the trust for 5 years.
It has to be in the trust for 5 years to be completely exempt. Typically what you're going to look at doing is using your retirement accounts, individual retirement accounts, as a first line of what you're spending if you go into a nursing home. Because the individual, the person in the nursing home, has to spend through those before they could be eligible for anything. They don't require the community spouse to spend their retirement accounts or individual accounts, but then they look to joint. So if you have to spend privately through those retirement accounts to get to the point where you might qualify anyway, you're needing 1.5 to 2 years of private pay funds to get into any kind of a facility that you'd ever want to even consider. Most places are saying 1.5 to 2 years. And so let's say we're only 3 years into our 5 years, you're going to look at paying 2 years privately anyway. And so we then got ourselves all the way through that penalty period, that 5 years. So it is 5 years, but most often it's 2 to 3 that we really need to be into it, and then you're going to pay privately anyway because you have to spend those funds, and that's what's going to ensure you get into a decent facility.
If you put a home in the irrevocable trust, and you look at the downsides, take on the condo type stuff, it still has to be processed through the trust, or can it be handled that way, or how does that work?
Yeah, so you're the trustee. So you're going to sell it as the trustee under the name of the trust, which is really no different. You're just signing trustee after your name when you sell it. You're downsizing, you're buying a less expensive piece of property, and you're going to put the excess proceeds from the sale of the bigger house into an investment in the name of the trust. Everything stays protected. So you can move around how things are characterized in that trust. You just can't take it back out or spend it. Okay? Yeah.
If you have an irrevocable trust, and like you said, say you've done your 5 years.
Yeah.
But down the line, maybe you get sick. Can you put other things in, or does that 5 years start all over?
So that's a great question. So when we make subsequent additions to the trust, the 5 year starts for what we add. It doesn't impact what's already in there. So we want to have a meaningful discussion about what can we add, and do you have enough to make sure you pay through whatever that penalty period is if we add stuff. So most people can get away with adding certainly some more than what they originally had and still have enough funds to pay through the penalty period. But that's where it's really important that you don't just look at this as a static arrangement, meaning if somebody gets sick, or you get to just be older and you realize, I have this account, I'm not going to spend it now, my days of traveling to Europe are done, let's protect it. And you can add it then. So you kind of have to be mindful of every couple years, or if something happens health-wise, that we have a conversation about whether or not we should be adding more stuff to it. Because again, if you can spend it, the nursing home can spend it. And that's the expectation, is that you'll spend it. Okay? Yeah.
As far as a home goes, if one spouse goes into the home and the other one doesn't, and then the spouse dies and the person who's left over says, well, I'm selling this home now because I don't need anything this big, I want my little condo or whatever. Can the nursing home still go after that asset?
So if it's not in an irrevocable trust, yes. Even if the community spouse is still living in the home, this is one of the big sort of misnomers about Medicaid. Medicaid will tell you that if you have one spouse in the nursing home and one spouse in the community, that you get to keep the primary residence, you get to keep one vehicle, you get to keep burial assets for each of you, and then I've got a slide here about the exemption amounts, but and you get to keep a certain amount of cash. You don't actually get to keep the house. You get to live in the house. And what I mean by that is they will put a lien on it for the amount of care that they are covering for the institutionalized spouse. And if it's a couple years that they're in there, it's not a maybe. It is a guarantee they will put a lien on it. And that lien gets satisfied when the community spouse either moves out, sells it, passes away, whatever it is. I mean, it could be $300,000 or $400,000 lien easily if they've been in the nursing home for a number of years. So there goes the equity you had in your house. You don't get to keep it. It's super important that you understand that you don't get to keep it. You get to live in it. They don't kick you out. It's super nice of them. They don't kick you out. Really, they don't kick you out, though, because it's less expensive for them to let you live in the house and give you some allowances to pay your bills than it is to institutionalize the community spouse as well. And that's why basically they let you stay in the house.
But you can't trade one piece of property for another, because then they're going to go after that first piece of property in your SOL.
Yep. It's a good way to put it. Yeah.
Did they put a lien on the entire value of the house, or is it 50%? Because your spouse is 50%. Is it the entire amount?
Yeah. I mean, it just keeps accumulating. They just keep adding to the lien for however often they do it, whether it's once a year or however often they do it. Yeah. It doesn't, it can be more than 50%, yes.
And then how did they look back 5 years? I mean, are they looking at checks that you've written out?
Yeah, so if you apply for Medicaid and they request documentation for up to 5 years, they can ask you for everything. I mean, it's like an IRS audit. They can ask for every check. What was it for? Where did the funds go? What was a gift? What did you spend at Potawatomi? I mean, there's really nothing, and they can see everything. They'll be like, I know you had a life insurance policy 17 years ago. Where did it go? I'm kind of kidding, but I mean, they can see things that you might not even remember you had. So if you think you're going to scam Medicaid, think again. are very resourceful, and they will know what you had and what you started with and what you should still have in their mind.
So then if they identify that you gave some Christmas checks or helped somebody with college or whatever, how do they recoup that money? Do they go to
Yeah.
the person?
Nope, they go to you or your agent, whoever's helping you, and say you either need to get this money back, which isn't happening, or you're ineligible for that many months. So let's say you gave away $20,000, that's 2 months worth of care, you're ineligible for 2 months. Well, now you're even more SOL because now you need the care. You know, it's a bad situation to be in. So it's the other reason why I don't recommend that people transfer their house to their kids as a means of getting it out of their name. One, because you give your house to your kids to hold during your lifetime. Just keep it in your name, Sally and Johnny, and don't do anything, I wouldn't do. If they get sued, your asset is their liability. If they get divorced, well, there goes your house. Lots of things can happen that aren't necessarily the fault of your kids, but you have no control over that house now. So all the things that can go wrong in the universe to your kids, your house is just, there it goes. So there's several reasons why people think that's a great, cheap way to do it, but that's another scenario where they might have to, quote unquote, give it back, and they can't, or they won't, or lots of things that, can happen that intervene there in that perfect plan you had. Yeah.
What if you sold a cabin a year ago, and you got money for it, and it was shared with a couple other people?
Okay.
Then you have to let your trust know. You have a trust.
You do have a trust? And it was in the trust? And is it irrevocable? If it's revocable, then you don't need to do anything.
Oh.
Revocable trusts are kind of like an ATM. You can put stuff in, you can take stuff out. No restrictions on that because there's no protection. Irrevocable trust is more like a safe deposit box. What we put in there, we're intending to leave, we're intending to protect. We're not taking stuff in and putting stuff out back and forth, back and forth. Okay? This is sort of where we were just touching on Medicaid. So Medicaid is, Title 19 is what covers you if you meet the indigency standards and you're in a nursing home. And the 5-year look back, again, it's going to start from the date that the snapshot of when you entered the nursing home. So you're going to have to spend down assets to be eligible for this. But part of the benefit of setting up an irrevocable trust is that we are creating an eligibility for you that you might never have gotten to, or that at least you wouldn't have gotten to as quickly. Because if we're taking assets out of your available funds to pay for the nursing home and putting them over here in the protected box, and they've been in that box more than 5 years, you're going to be eligible for Medicaid sooner because you don't have as many assets you have to spend through. And if you get into a facility and you pay for their private pay rate for 2 years or a year and a half or whatever it is, the vast majority of facilities accept Medicaid, and they can't kick you out after those 2 years once you've met their criteria and you're now eligible for Medicaid. So they can't. It's illegal for them to kick you out at that point in time. Okay. So then Medicaid ends up paying the difference. Okay. And again, this is where it talks about the couple can retain the house and whatnot, but there are rules. It's not just you get to keep it and you get to do whatever you want with it. They're putting a lien on it if you don't have it in the trust. Yeah.
Do you see any changes in what Trump wants to do that's serious or something we should look forward to?
The only real thing Medicaid is going to be in trouble. I mean, it just is. And I don't know what that's going to look like. I don't know how to reconcile if huge chunks of Medicaid go away. I mean, a lot of people don't really understand Medicaid. Medicaid covers lots of things. It covers what we call food stamps, right? It covers everything up to nursing home care. People who are on Medicaid or in nursing homes, they're on Medicaid because they meet that indigency standard and they can't afford to pay privately. So I don't know what happens when all of a sudden there isn't Medicaid, or at least not to the extent that there is. So I don't know. It's going to be a trickle-down effect when we've got people who need the Medicaid services and there isn't that funding. So there's also some issues with the possible estate tax exemption. So if the exemption goes away, or changes under some of the policies they're looking at implementing, we might lose what's called a step up in basis. So the step up in basis means that if you assume your parents' home, or your kids assume your home, they get to take it at the value it's worth at your date of death. So if you bought it 50 years before for $20,000 and it's worth $2 million now, they don't have to pay capital gains on that difference. They get to take that step up in basis when they sell it. If that goes away, that's huge. That's going to be a really big problem. So these are all things that are just percolating, and I don't know what's going to happen with them, but certainly we're mindful of it, and if there are changes, we'll implement these into any plans that we make. But we don't want that step up in basis to go away. That's a really critical value that people have when you retain property until your death and then it gets sold. So when I was mentioning the community spouse, and there's certain amounts that the community spouse gets to keep, you get to keep about $157,000 if you're the community spouse, and plus $2,000 for the institutionalized spouse. So Medicaid has this very elaborate equation that they use for how much did you start with, how much do you get to retain if your spouse goes into a nursing home. So the community spouse does get to possibly retain a portion of the institutionalized spouse's income. So let's just say the husband is the one who goes into the nursing home. He has higher Social Security, he has a higher pension, wife is living in the home. They do allow traditionally some portion of that institutionalized spouse, so the husband's income, to still stay with the wife in the home so that she can pay property tax bills, utility bills, things like that. Again, it's called spousal impoverishment, and it's sort of that idea that it's cheaper to allow them to keep some of those funds than it is to institutionalize the community spouse as well. So we talked about the 5-year look back and the protection trust. So really, if you know you want to protect your assets, the ideal time to do it is 65, 70-ish, or whenever you've got your real estate paid off, because that's the first thing we usually fund it with. If you wait till you're 90 and you come and see me, I might be able to help you, but it's not going to be nearly as effective, because what we want is to use that 5-year look back as a 5-year look forward. Meaning if you set up a trust, an irrevocable trust, in 2025 and you fund it in 2030, we've dealt with that 5-year look back already because we've looked forward. Now anytime after 2030 that you go into the nursing home, it's considered exempt. So if you wait, you have that 5 years to contend with that may or may not work. So 70-ish retirement age, whenever you've paid off your real estate, is really the ideal time to do the asset protection planning if that's what your goal is. You can do the revocable trust anytime because that doesn't have any look backs, it doesn't have any of those rules. Okay. So again, sort of that which the settlor, so when you set up a trust, you're the settlor or the grantor. Whatever you can't access, the nursing home can't access. So you are putting it in there, you are voluntarily not spending it, under the premise that then the nursing home cannot spend it either. So it is a bit of an honorary arrangement. You could decide you want to blow up the trust and say, I'm going to sail around the world and spend all my money, and I don't care anymore if it's protected. And you could do that as long as neither you nor your spouse had already been in a nursing home receiving Medicaid. If that's the case, you wouldn't blow it up then. It's already doing its job. But if neither of you is sick and you just decide, go off into the sunset Jimmy Buffett style, you could blow up the trust, you could take everything out, you could go and spend all your money. There's no penalty, there's no fee for blowing up your irrevocable trust at that point. So part of the biggest fears I hear about irrevocable trusts are, one, you don't have any control. Not true. You control it, you are the trustees. I hear you can't change it. Not true. You retain what's called a power of appointment. You can change the percentages you're giving, you can change your beneficiaries, you can change any specific bequests you've made, you can change who your trustees are. Those are all the things you'd really care about changing anyway. So under that power of appointment, you retain that. And then I hear that people are afraid that it's forever. I mean, the goal is it's forever because that's how it works. But if you decide to blow it up, like I just was talking about, you can do that. And as long as you haven't been receiving Medicaid already, you're not penalized for blowing it up. Makes sense? So lots of these things, if you go home and you Google this, irrevocable trust, you're going to find all kinds of stuff that may or may not be relevant either to Wisconsin or to the type of trust that we're talking about. Take it all with a grain of salt. I had a guy tell me last week his eye doctor told him irrevocable trusts are terrible. I did not weigh in on what kind of eye care he should get. So, I mean, be mindful of where you're getting your legal advice from. Because your neighbor maybe didn't go to law school. And, come and ask the questions. I'm happy to answer the questions, whatever the challenges might be, whatever you read or whatever you've heard. And if it turns out that it's not for you, great. I'm not trying to sell it to you. I'm trying to make sure that whatever the plan is you want, we put in place. If that's an irrevocable trust, great. If that's a will, fantastic. But I want to make sure I've dispelled the myths before you go down a path of setting up a plan just because you heard from your neighbor that such and such is the case.
If you put money and your house in an irrevocable trust and you decide you put too much money in, you have to take some out. So you take out whatever money you want. How does that affect the irrevocable trust?
Your whole 5-year look back is starting over because you just breached the terms of your trust.
Okay, even for your house?
Yep.
Gotcha.
So again, you can do it. You're just starting over with your 5 years for everything that's in there.
Can you have more than one irrevocable trust?
You could. You could. I don't foresee too many scenarios where it would be necessary. Sure, yeah, you could. And I also oftentimes have people who do both types of trusts. Several reasons. One is, let's say you own a property that you rent. You don't necessarily always want to own it. You're going to put that in a revocable trust to avoid probate. That way, when you decide you've had enough of being a landlord and you sell it, you can take that money and do whatever you want with it. But we put your primary residence in the irrevocable and start the 5 years for protecting that. So 2 different trusts serve 2 different purposes, and a lot of times people need both. If you're not sure what you want to do with a piece of property, let's get it in the revocable, and so it's at least avoiding probate. And a lot of times I had 3 yesterday who literally are super close to paying off their mortgage and know they're going to want to put their property into the irrevocable. So we created both trusts at the same time. It's never going to be less expensive if you come back in 5 years, to set something up. And now we're starting over with the whole process. So if you create both types of trusts, put it in the revocable for now. When you pay off the mortgage in a year, we just do a deed to move it into the irrevocable because now that the box for the irrevocable is already created. So if you're close to paying off your mortgage and you know it's what you want, a lot of times people just create both trusts right off the top. And then the revocable trust pours into, like our will, pours into the irrevocable at the end of the day. So if you still had assets in both, we're only administering one trust upon your death. We're administering the protection trust, the irrevocable trust, because of the pour over nature of the revocable and the will. So we're still trying to make it as easy as we can for whoever you put in charge of handling your estate. Okay. It's super important that you're working with a financial advisor, a tax person, an estate planning attorney. And I will readily admit that I will tell you 10 things and you'll go tell your CPA or your Drake person and they might go, that doesn't make any sense. We are all looking at it through our own lens, right? So the advice that we give is through our specialty. So where I said the Medicaid rules and the IRS rules don't really jive, oftentimes the advice that you get from a CPA and a CFP and an estate planning attorney, it doesn't always perfectly meld. So we have to take what I call what's the bullet you're most imminently dodging and dodge that bullet and get on board with a team where we can all dodge it together. And so sometimes that means, I work with the Drake advisors, us looking at things in a different light than you might look at if you were 40 years old and you were investing. So what can we protect? What do we need to spend? What might we convert into a Roth so that we can put it in the irrevocable? So looking at things differently, but just knowing that when you consult with 3 different professionals, you're going to get a little bit of a different slant on everything that we talk about because we're all looking at it through our own lens. So you have to take from that what makes the most sense for you. And in my mind, when you get to this age, what you're most imminently dodging is the nursing home bullet because it's really the most devastating in terms of what it takes if you didn't do any planning. Makes sense? All right, I think that's, yep. All right, questions? Yes?
So if your assets that are like CDs or savings accounts in either one of the trusts, you have to do a trust tax return every year? If it's more than 50.
Fabulous question. When we transfer assets into a trust during your lifetime, it's called an incomplete gift transfer for IRS purposes. So we are not getting a separate EIN for your trust during your lifetime. Everything that's in either trust is going on your regular 1040 tax return. We are not filing a trust tax return until you have passed away. That is absolutely by design. So you don't have to do anything different tax-wise with either one of the trusts once you fund assets into it.
So is that something new that's been set?
No, it's just yes and no. I think there are some attorneys who still draft things that way. It doesn't make any sense because trust tax rates are higher than individual tax rates. So we don't need to file a separate trust tax return until you're gone. It's just set up that way.
Then your assets don't show the trust name on it because the bank.
They do.
The bank won't take it unless you have a federal ID number.
It's under your social security number, and the document, page 1 of the trust says, no new tax ID number and it cites the IRS code. It is an incomplete gift transfer. So they have to. I've never had somebody come back and say that they won't. I mean, banks are my Achilles heel because they like to do things that I don't think make good sense sometimes. But I would help you if that happened and they told you that because they're wrong. If the language in the trust specifically says you don't need a new EIN, then it's going through your social security number.
I'm sorry, I think you've already addressed this,
That's
so I
okay.
apologize, but I just want to be clear. You put your house in an irrevocable trust, and then you decide you want to sell it and buy a different house, and keep that in the trust. That doesn't reset the clock, and it all stays in the trust.
Correct. As long as you're selling it under the name of the trust, you're buying the new property under the name of the trust. Now, you can't take a mortgage on the new property because you can't have mortgaged property in the trust. So that is something to bear in mind, that even downsizing these days might be upsizing in price. So we have to work within that and make some decisions about that. But if it's dollar for dollar or if you're buying something less, you can absolutely do that under the name of the trust and not breach the 5 years. Yeah.
If you happen to have long-term care insurance, on a revocable versus irrevocable trust, which would you start with these days?
So long-term care insurance is great, except that it is never going to cover the entire cost of your nursing home care. You have to really look at what your policy says. A lot of them have a max per diem or a max month, and that per diem might be $180 a day or $225 a day. A decent facility is costing you $425 a day. So you're going to be on the hook for the difference. So doing an irrevocable trust isn't going to be wrong because you're really just trying to shore up even that difference that you don't have to pay. But it's less critical that you do an irrevocable if you have a good long-term policy. It's just you need to understand what it actually does for you. Because if you got it a long time ago, they really haven't kept up with the rates of nursing homes, and they cover maybe a third, sometimes a half, sometimes nowhere close to that. So you need to understand what it does for you. Does that make sense? Oh, yeah.
So I probably have a mess, and I probably
I like messes.
Here's the thing. I have a irrevocable trust. The house is in there. There's some money in there.
Okay.
And when I went to the tax guy, and he said, you can't pay the insurance, and you can't do that.
I want to talk to this tax guy.
I tied a checkbook to the trust.
Yeah.
And then I wrote checks out of the money in the trust to
Yep.
pay that.
Yep.
Now the whole 5 years starts all over because I wrote them checks?
Not necessarily. If you wrote checks only to benefit an asset in the trust,
Right.
you're probably okay.
We better figure it out.
We should. We should. We should. Yeah, we don't probably really want to rest all of it on probably. That gets to be a little precarious and dangerous. But you might be okay, so we'll talk about it.
How often, if you've gone through all of this, how often should you
Look
see
at?
someone like you to go through it
Yeah.
again?
Yeah.
I mean,
That's an awesome question, too.
years ago, should we be doing it again?
So trusts themselves, some attorneys set it up where you pay some annual fee and you come in and you talk about your trust every year. I don't believe that's necessary. What I will tell you is necessary is if there is a change in circumstances since you set up your documents, meaning you got divorced, one of your kids maybe predeceased you or is estranged from you, or the people that you've named as your healthcare agent and as your trustee, if any of those things change, we need to talk about it. Because maybe we've got secondary things set up, but maybe the whole landscape has changed and we might need to amend or do a restatement. So you know when things change. You should contact your attorney if something substantive enough changes that it gives you pause. That being said, if you did your plan long enough ago that you don't even really remember what it says, never hurts to just kind of review it, because entirely possible that things have changed, and you can amend almost any kind of trust and just bring it up to speed. I mean, every 5 years probably, just to kind of pull it out and look at it, but that still doesn't mean that you necessarily need to change anything. Trusts don't really become outdated just because they're old. They become outdated if the people you've named and the intent behind them isn't what you want anymore. So if something changes in your circumstances since you set it up, that's really when you need to reach out to the attorney who drafted it, or to another attorney. Most attorneys can amend other attorneys' documents.
If you have like an IRAs and 401s in a trust,
You can't have them in a trust.
401s, IRAs,
No, and there's a tax reason behind that. So, but sorry.
Right, so then that's where the payable and death comes into play, stuff like that, the shift and probate. So if those can't be in a trust, then how do you can't protect from?
You can't.
You can't. So IRAs, 401s, all that, mutual funds do not go in trust.
Correct. And it's because of the RMD age. So if you put something in a trust, you take it out of the individual's name, it doesn't trigger that RMD, and the IRS says no dice. They want to trigger that RMD requirement. So you cannot put qualified retirement accounts into a trust, which is what I mean, again, by spending what you have to and protecting what you can. If you go into a nursing home, you can't have protected those retirement accounts. You have to spend through them. So that's when we look at getting more aggressive at protecting other non-qualified assets that you might have not looked at before, because you're always afraid to take distributions out of your IRA. You might have to if you go into a nursing home. You will have to if you go into a nursing home. So we spend what we can't protect if you go into a nursing home, and we protect what you can. And that's kind of a different thing to wrap your head around, because that's just not the way most people look at it. If you need a new roof, you're going to take it out of your money market or your savings. Maybe not. Maybe you're going to protect your money market or your savings, and you're going to take it out of your IRA because you'd have to spend it anyway. So it depends on your scenario, but it's not as cut and dry as never touch your IRA. Yes, you're going to pay some taxes on it, but if you have to own a nursing home, they don't care that you have to pay taxes on it. You're spending it all until it's spent down. I know everyone's going, what the heck? Yeah.
Did you say you can put your Roth though?
Roths can. So Roths become a non-qualified animal once you have paid the taxes on them to convert them. Roth, when you convert them, you pay the taxes on them, so they become a non-qualified asset. They can go in a trust, yes. Life insurance, whole life insurance can go in a trust. That's a great thing to put in there, again, because you're not tapping into it usually, you're not living off of it, but if you end up having to cash it in for Medicaid, if you don't protect it, they're going to make you cash it in for the face value, which might be like $20,000, and the death benefit might be $250,000. They don't care about your death benefit. They care that it's a viable cash asset right now. So whole life insurance is another thing we often fund irrevocable trusts with. It's a super easy thing. Pardon me? Term can't go in there. Term has different rules, so term can't go in there.
Did you say something earlier about if a spouse needs to go into a nursing home, that the other spouses, like IRAs, are like sheltered?
Yeah, they don't expect you to spend through your retirement account to pay for the institutionalized spouse.
So if one spouse is heavy on IRAs and one isn't, the one that's heavy on is going to get wiped out?
Yep, unfortunately. Yeah.
So who can create these trusts for you, and are there ongoing management fees?
Also good questions. So you, as long as you have mental capacity, you can create the trusts. They're all self-funded trusts. I don't do really third-party trusts, so you would have to create them yourselves. You'd be the settlor or the grantor while you have the ability to do so. There are no ongoing fees, at least not for me. Other attorneys do things differently, but I don't have any ongoing fees to have a trust. And if you work with me, the social worker side of me says, I want people to always be able to call and ask a question about what we did, and I'm never sending you a bill for a phone call, ever. If you email me, if you want to sit down and look at your plan, as long as we're not changing anything or creating any amendments, I'm never charging you another penny to just go over what you've got, call and ask a question. If we end up doing an amendment, that's an hourly charge, which is really nominal. I mean, to do an amendment. An amendment is like if you're changing who your trustee is or you're changing who your beneficiaries are. But part of working with people is I want you to feel like we have this relationship where in 10 years you call me and go, you told me one thing sometime about this and I don't remember what you said, and we talk about it and you go on your merry way and I don't send you a bill for a 20-minute phone call, because I'm not doing that. And anybody who's worked with me will tell you in the entire time I've been doing this, almost 20 years, I've never sent anybody a bill for a phone call or an email or a review meeting. That's part of the buying into working together. Yeah?
Where are all the original copies and the wills and everything held? Are they held in your office or are they held in the cloud?
I do not retain originals. And part of that is because years ago attorneys used to retain originals, and then when you came back to get them, they charged you money to get your originals. Which is a huge ethics problem. So I'm giving you all your originals. The only thing that you really must always have the viable original of is the will. Everything else now we can work off of copies. So I have scans, you'll have the originals, you have this whole binder. Advisable to keep it in a fireproof, waterproof container. If it's a safe, make sure the people you've named in it can get to it, know the combination. I don't advise putting it in safe deposit boxes, because if you don't put your kid's name on the box, they can't get in it, then they have to go to court, which we tried to avoid. So we can work off of copies. We used to have duplicate originals for everything. We don't anymore. POAs and things like that can be scanned now. Even a trust, we can work off of a copy. The only thing, if it ever got lost or destroyed, we need to re-sign is that will. So.
I was at the bank yesterday and they said they're doing away with safety deposit boxes.
A lot of banks are, and I don't know, I don't really know, I mean, it probably just has a falling out with it, but yeah, a lot of banks are. I mean, your best bet is to scan the documents that you want to be able to send to people, like your healthcare power of attorney. You're going to want to bring one with you if you ever have a surgery, things like that. But otherwise, everything is staying in the binder that I give you, and I could help recreate everything except those wills that we really want to make sure we've got always a signed original of.
What do people like in California when they had all those fires? What do they do? Everything's gone.
It's not good. I mean, and so I'm not naive when I say that if your wills ever get lost or destroyed, we need to re-sign them. Things happen, right? So we could always recreate the will, and we could re-sign it. You just have to be mindful of knowing that it got destroyed or lost. Yeah, a lot of times people don't know, or their kids don't have any idea where their original will is, or the ever popular years later, somebody finds the will and it's not the way the estate was supposed to be administered, and then we got real problems. So make sure that your people know where to find the binder in your house. And if it gets destroyed, we just need to re-sign what we need to re-sign. Yeah.
Is there an annual fee for either kind of trust, or just one and done?
It's one and done.
What's the average cost? I know it's hard because some can be very complicated.
So traditionally, my costs are the same. It's a flat fee, again, for almost any kind of situation, unless you've got some real weird one-off. Most often, a revocable trust plan, which includes the powers of attorney for health and finances and includes the pour-over wills, for a couple, it's going to be about $4,000 to do all that. For an irrevocable trust with those POAs and the pour-over wills, it's about $5,000. So not inexpensive for sure, but a lot less than a nursing home.
I was raising my hand for her.
Okay.
Hands like
Oh,
this,
sorry.
and
Yeah.
But
What's
she
your?
said that you just answered.
Oh, okay. Yeah, I mean, people will call and, well, you know, what's right? What I'll tell you is the consultation is free, always. So come and talk to me, and I will tell you exactly what your situation is going to cost, rather than, you know, kind of ballparking numbers. But largely, those are the numbers that we're sticking to, unless you've got, you know, weird situations involved, and then we go from there.
How long would it take for the process for say, a basic estate plan?
Well, that is another fantastic question. A lot of attorneys will send you like a 10-page form you're supposed to fill out and get back to them. Then they draft your documents. Then they send you your documents, your drafts to read, and call them when you're ready to sign. That's the dumbest thing I've ever heard in my whole life. you're going to come and sit down. We're going to have an initial meeting. Maybe that meeting is our design meeting because you know you want to move forward, or maybe you're just going to get all the information and the cost. Then we do a design meeting if it's not in that first meeting. All I need are your kids' names and dates of birth or your beneficiaries' names. We're going to talk about who do you want your power of attorney to be, who do you want your beneficiaries to be. I'm going to take all that down. I'm going to draft it all, and we're going to meet again in a week or two, go through everything together, and sign it together. If there's changes that need to be made, we're going to make it right then and there before you sign it. So start to finish, usually it's about 2 weeks. 2, possibly 3. If you come to the initial and you're not sure what you want to do, then we're going to set up a design for when you're sure what you want to do. But the initial can be the design if you come in and know that you're ready to jump in. It's 2 meetings. And it's usually a week or 2 from start to finish.
Where are you located?
Right here. That back corner. Yes?
I have a question. I'm a Vietnam veteran.
Okay.
I had always assumed that when if I needed a nursing home and a VA home, what does the VA confiscate compared to a regular nursing home?
A VA depends on whether or not you're service connected.
Okay.
So if you're service connected, you might not have to pay anything.
Yeah. In my case, I came up without a scratch. So.
Okay, well, then probably not service connected. So then I'm not 100% sure. Usually, though, those benefits are better than the average Medicaid situation. But the difference there is going to depend on whether or not you're service connected, and that you'd have to ask them about. I don't specifically usually deal in VA stuff, so. Yeah.
So if you want to create a revocable and irrevocable trust,
Yeah.
Would it be an average of 9,000?
No, it's actually 6,000. So it's basically 4, 5, and 6. If you're doing both, it's 6. I mean, it saves you a ton of money to create both right away if you know that's what you want to do. Because if you come back in a couple years and do it piecemeal, it's going to cost more. It's just.
And that's something that you could discuss at your initial
Absolutely.
consultation.
Yep.
That, hey, you guys would benefit from both.
Yes. Yes. Yep. That's what we talk about. Yeah.
Do you need to be a Drake customer with other services to be your customer?
No, you do not. I am happy to work with all Drake people, but we are independent businesses. So I have a lot of people that are not Drake people. Drake has a lot of people that are not my people. We have a lot of good reciprocity with our services, but no, you do not need to be a Drake client to work with me. I'm an independent business.